Hey guys, good morning. I'm JD Houvener, managing partner here at Bold Patents Law Firm, and we're live across 3 platforms: Google, YouTube, as well as our Facebook and Twitch audience. So thanks for coming on. If you're watching after the fact, make sure to give us a like and share this with your community out there in social. We're making this a weekly event. I've been doing this now for about, about a year. I'm here every Wednesday morning, 9 a.m. Pacific, noon on the East Coast, as a patent attorney, as the owner of the law firm, giving you answers, right, to anything patent related, IP. I'm happy to answer questions on trademarks as well. I'm going to put in the comments here our disclaimer. Obviously, this is a public forum. Do not share invention details, confidential information. Do not do that. Just ask questions about the patent process. Ask questions about, hypotheticals. Okay, situations you may be in if you filed already. I've got a couple of viewers on already. It's good to see you guys. This is an open forum. I don't have any specific agenda. I want to make sure I get to any live questions first. And for those of you that are just getting started, you see the books behind me over here. Bold Ideas, The Inventor's Guide to Patents. This book we're giving away. This is a guide, right? If you're a first-time inventor or just thinking about inventing, this is the book for you. I've got it available for free, PDF download on our website at boldip.com/contact. This is your time, right? So I'm happy to answer any questions you've got that you're working on. Maybe you've got, a day job and you've got moonlighting a project on the side. You want to think, well, what does it take to get a product patented? Is it possible to actually make money with a patent? What's the difference between a provisional and non-provisional? I'm happy to walk through any and all of that with you guys today. So what I'll do is leave the channel open. We don't have any guests today, so it may be a short broadcast, but I want to make sure I give you guys enough time to come up with questions. I will go to our avo.com questions first, because I don't have any live questions right now. So these 3 came in the trademark application area. This first question is out of Cuyahoga Falls, Ohio. I know what a trademark is, and I just need some good detail about trademark. I'm trying to get a clothing line named trademark, and I wasn't sure what the different type of trademark is for local and global. So I'll put this question in the Facebook channel in case you guys missed it. So question number 1, Avo. Looks like this. There we go. So there's the question. This person is looking to get a trademark on a clothing line. All right, so clothing, a lot of first-time business owners, entrepreneurs, people that are interested in starting a clothing line have a misconception. And I think this may be true for this question asker as well, is oftentimes people think that to protect a logo or start a brand, it's what's on the front of the shirt that matters. And that's actually not true, okay? The artwork that's on the front of the shirt is actually part of what can be controlled under copyright law, because it's just artwork. Brands and trademarks actually describe companies, right? Actual what people can associate to specific goods, right? So they know where items like shirts come from. So what's more important actually is what's on the tag, right? The tag in the back. That's what matters. I don't know what brand this is here. Let me show you guys. Yeah, you can see that it's got the name of the company or the brand that they want to be known as on the tag. So that's what the trademark office will look for, because they want to actually be required to submit evidence that you're using your mark in commerce. So that's the path to go down on the trademark side. So for US versus global, which was the other part of that question, of course, the US Trademark Office can only grant legal rights and protections in the US. If you want to seek trademark rights overseas, there are treaties in place, and we actually have affiliates who work as intermediaries between the US and other foreign jurisdictions. Many countries outside the US will actually recognize the US Trademark Examiner out there. Hey, how you doing there, Petricor? All right, good to see you. Thanks for hopping on. Any questions, fire them away. I'm happy to field those. This is kind of fun. This is probably the 7th or 8th time we've done this across Google, the YouTube Live, Twitch, and Facebook. So happy to answer anything you guys have got. So that's trademark law. Okay, let's jump to the second question from Avo. We have this one coming out of St. Louis, Missouri. I'm waiting to incorporate a trademark logo into another product. Specifically, my hobby is handcrafting beverage containers, like cups and tumblers. I wish to purchase a decal and apply it to the cup and then sell the finished product. Nothing would be altered or copied, if that makes a difference. So they actually make something. They actually make the cups and tumblers. I'll put this question in to our Facebook community here. There we go. So here's this question. All right, Flavio, I'm going to jump to you right after this one, okay? Thanks for hopping on, buddy. So wanted to incorporate a trademark logo. Oh, sorry, I did that already. Okay, so there's cups and tumblers. They want to put a decal and put it on the cup and then sell the finished product. So you want to use like a Nike decal or an Adidas decal. That will be a problem, right? Okay, because you're using someone else's brand for commercial use, commercial gain, okay? And so obviously if you're making these cups, they're beautiful, they're unique, they're yours. Certainly you can sell the cup. But as soon as you start putting someone else's logo or identified brand material on your cup and sell that, you are infringing on their trademark. So that would be a no-no. Okay. All right. Thank you. Hope that's a pretty straightforward answer there. Flavio, I want to get to you. Let's see what your question is here. Thanks for coming on live. When you file a provisional patent application, does the examiner review it and give you a year patent on your invention? Awesome. Good question, man. And this is kind of funny. When I clicked on it, it made your question nice and big here. No. Okay. Provisional patent applications do not get examined. The beauty of a provisional, the main function of it is to lock in that priority date, right? The laws changed in 2013. It's no longer who was first to invent it. It's who is first to file it. And so it's a race to the patent office. And so if you've got your provisional filed, any inventor that comes after you, right, with the same invention will lose to you in a priority battle. That date is locked in for 1 year. You got that part right. So within a year, you have to file your non-provisional patent application to secure that priority. You'll need to, at that point, file that formal full application, which includes the formal spec, drawings, claims, any specific documents with related to your entity size and assignment. So the examiners don't look at it. They will only look at the non-provisional, right? The actual claim structure. And the only time that they might actually look at the provisional is way late in the game, is if they had a second invention get filed. And there's sort of a controversy where who filed first. They will then crack open the provisional and make sure that it was indeed what you discussed in the non-provisional later. So thanks for your question. All right, keep those coming. Good question. So I'm going to finish up with our third question on the trademark side. This question comes out of Stuart, Florida. Do I need to file a statement of use? Okay, so statement. This is a long question. Let me just get this all put into the Facebook Live for you guys so you can follow along. All right, and I'll try to put sort of the essence of the question here. Whoops. So on YouTube Live, it looks like they broke up the question. That's funny. So like, right, this first question ends with incomp, and then the first word on this next one is ass various. Please don't read that as a split question. I might just, I don't know what to do about that. So do I need to file a statement of use for every product in the class, or is one sufficient to prove commercial use? I previously filed my logo and my company name for an intent to use under class 3 to encompass various cosmetic goods. 4 months later, and I now have an actual product displaying my logo and company name on the packaging, and I shall be selling soon. I have manufactured hair gel, a hair pomade, and a body moisturizer today. So the question, I believe, is about, hey, did I cover it properly, right? Did I have enough classifications listed for my specific brand? And it's always a tough question, right? When you're getting ready to, you bet, Jake. When you're getting ready to launch a brand, you've got to be forward thinking. You've got to be thinking not just, hey, what am I selling now? What do I want to sell next year? What is my company going to want to be in business selling 10 years, 20 years down the line. And it's a tough one, right? It's a lot of business planning. So when you go to file that trademark application, you got to think beyond what you're currently doing and think about the end game of where you want to end up, and go for that, right? Cover the scope of not just cosmetics, but cover body care or health care, maybe even consulting services. And those are all different classifications. This question asker may have already filed, and so you can certainly come back at a later date and file a subsequent sort of an update. And you'll see that if you go to tess.gov, that's a trademark electronic search system. Why don't I jump there right now just to kind of show you guys what it looks like. So I'll share a screen and jump over to the trademark electronic search system. Okay. So hopefully you guys are seeing that. I'm just going to put in TSS trademark, and there it is, search trademark database. Let's think of kind of a famous brand. Anybody out there want to look one up? Let's think. Let's go with I don't know, iPod, Apple. All right, super famous computer mark. So with Apple, just plug that in, you get 4,500 results. Let's try something more specific. Let's say McDonald's. And I'll go back here. Let's do a basic word mark search. Okay, so let's just see what this is. So McDonald's, okay. So they've got a registration here. They filed it in 2019, okay? And this is the McDonald's that we know, McDonald's Corporation in Delaware, right? The worldwide McDonald's. And they've been around a lot longer than 2019. But you can see they're still filing trademarks. They've actually now got a registered trademark covering these types of goods and services under class 22, 23, 38, and 50, covering action figures, toys, plush toys, toy vehicles, right? You wouldn't think that McDonald's is a toy maker, but they actually filed again and updated their trademark registration to include action toys, right? All the different things that probably end up in, Happy Meals. And that's probably one of several, right? You can see all these different trademarks that McDonald's has applied for. This is the actual logo. You can see how it's actually stylized. They first busted out this sort of logo, it looks like in 2004. So every time your business sort of refreshes and updates the way that it's presenting itself to your customers, you want to update and refresh your trademark filings. Our own firm, we did that, right? We actually started out as Bold IP. I mean, that is the name of our firm as we're registered with the Secretary of State. But about 2 years ago, we changed to Bold Patents. And so we now have a registration application for Bold Patents because that's the way that we're presenting ourselves on our website. So I just want to show you guys a little bit about that. I'll stop sharing. Let's see, Petricor. It's Alan. This is my company name, Alan. Oh, absolutely. Well, it's good to hear you. So I didn't know who that was. Thank you for hopping on. I appreciate you saying that. Very good. Thank you very much, Alan. Flavio, I know a provisional patent is a less expensive approach, at least for protection on the invention. It certainly is. It requires less work, right? It's less formal. And I tell people it's about half as much work as it is for a full utility non-provisional, because you can be completely wide open with the drawings. For example, we submit photos, rough, sketches at times if it's what's best. all the information possible about your invention, and just get the full disclosure out. We don't need to worry about formalities, flag notes, identifying different discrete detailed descriptions and claims that don't need to even be in the provisional. So it's a lot less work, a lot less red tape. And if you're worried about money, you want to make sure you've got the most amount of time to collect capital, test the market. That provisional is definitely the way to go. All right. We'll give it a couple more minutes. I'm ready to wrap up. There's no more AVO questions. We went through the trademark search system today. I hope that was helpful for you guys. And if you're watching this after the fact, send this off to someone who might use it, right? Social media is powerful. So if you've got your own little network and you think that there may be just one person or maybe someone in your whole community that could use this, right? Use the fact that I'm here every week, Wednesday, 9 a.m. Pacific, noon on the East Coast, to help answer, just to get you started, get those initial questions out of the way. Invite them, right? Forward this to them. That'd be great. All right, you're welcome, Flavio. And thank you, Alan. Thanks everybody for hopping on. Jake, you too. I appreciate all the guys and gals out there watching. Have a great rest of your day, and we'll see you next week. Go big, go bold.